The Internet allows for the speedy and efficient facilitation of material. However, its development has escalated the existing problem of child pornography. Therefore, it is essential for laws relating to it be up to date. So, in its current state, does the law adequately protect against the abuse of children, or has it overreached its aims? Section 2 of the Obscene Publications Act makes it an offence to publish obscene articles. Jacob explains the problem with the word obscene lies with juries applying subjective rather than objective standards. Articles has been interpreted widely to include computer-generated images, and the word publications has been stretched to mean any form of distribution or showing. Ivy Fellows demonstrates that publications can now mean the giving out of login details for access to illegal material. The approach reconciles the law of the advancement of technology, but has its meaning been overstretched? The Protection of Children Act and the Criminal Justice Act criminalise unpublished material that the Obscene Publications Act doesn't. While the Protection of Children Act criminalises the making of illegal photographs, the Criminal Justice Act makes simple possession of them an offence. Taine justifies this additional step, explaining that possessors of these photographs are complicit with the original abuse. The word photograph has been defined to include data stored on a disk or a computer, but the word making and the word possession have presented issues. Atkins against Goodland asks two questions. First, does data stored on a cache of a computer amount to possession, and would downloading material constitute making a photograph? Collier clarifies the position. Now, a person who has knowledge of caching will be deemed to have possession of a photograph. R. against Porter raised the issue that a person cannot be in possession of deleted images unless they had special equipment and knowledge to retrieve the deleted images, retaining control over them. But does a loophole exist in the law? It seems so long as a person deletes an illegal image and cannot retrieve it, they cannot be found guilty of possession. Act Dennis draws particular attention to this. In these circumstances, crimes are committed, but offenders cannot be prosecuted for possession. Downloading an image has been found to constitute the making of it, but a person must know of or intend the download. However, the law has inconsistent with this approach. In R. against Harrison, the accused didn't know of the downloaded material that was the result of a pop-up ad, but the courts held he should have known what was found to have made the material downloaded. The term to make has been given its standard meaning, and Act Dennis explains this interpretation is so that users down the line are caught, not just original perpetrators. The Criminal Justice Act extends the definition of photograph to include tracings or images created by electronic means. However, Maureen Johnson criticises this, explaining its great failing is pictures must be derived from a real photograph, describing the addition as having little advancement towards the protection of children. The Coroners and Justice Act overcomes this loophole, legislating against pictures derived from anything including the imagination. King explains there is a general consensus with regard to harm involved from children and child pornography if such drawings are distributed. But what harm is suffered by a non-existent child? Seems none unless there is a risk of a person acting on their thoughts. The Coroners and Justice Act ensures compliance with the UK's obligation under the Directive on Electronic Commerce, but should the law go further with search engines and host sites attracting more liability? Currently, information society service providers are not liable for illegal content unless they are aware of it and ignore notice it to take it down. It is important to note here they are more vulnerable to prosecution than actual pornographers, as they have identified operations and more susceptible to public pressure. So what criticisms has the law attracted as a whole? Antonio's research shows that possession of illegal images by possessors increases demand and consequently results with harm to children. Even pseudo-photographs used for grooming cause harm to children. Further, Antonio finds that pornographers are more likely to have sexually abused a child. However, he criticises the law prohibiting fantasy images for two reasons. First, no research on the use of fantasy images can conclude the same results as with real images, and no child is harmed in the process, and those in possession have not been found to propagate harmful attitudes, and therefore the harm principle cannot justify the criminalisation of these. Secondly, he argues the condemnation of possessing imaginary images goes on to form the basis of lawmakers to go on and create further offences, as lawmakers have tried to extend the possession principle to fantasy written material.